Okay, I'm hoping everybody can hear me. I am delighted to be here. Got a lot to cover today in a short period of time, and so hopefully I can at least spark your interest in this report if you haven't heard about it at all, and kind of encourage you to maybe read the surrounding text around these recommendations. So before we get started, as we are all used to hearing, these project sponsor disclaimers through NIST and NIJ. The opinions or points of view expressed in this presentation are those of the authors and do not necessarily reflect the official position of the US DOJ or the Department of Commerce. And then I also have a personal disclaimer here, since I am here representing the expert working group and not necessarily my current employer, the Kansas City Police Crime Laboratory, or any of my other affiliations with OSAC or the Texas Forensic Science Commission. Okay, so lay of the land today. I'm going to introduce you to a little bit of the background, why this.
Sorry, really quick, Jara.
Yes.
I don't think that your slides are advancing for the screen share. If you want to try, maybe reshare.
There's a delay. Yeah, I will stop and escape. And hopefully, so what are we seeing today? Are we seeing the plan?
It was originally just the title screen or the title slide.
Can you see anything now? Oh yeah, maybe
no, nothing currently.
Probably try to share again, right? Window.
For your patience, everyone, technical difficulties.
Okay, there we go. Now we've got the plan slide.
Hopefully it advances. So holler at me here when I'm done saying this last line. Sorry, y'all. So I have to talk a little bit about human factors and then introduce you to concepts you probably are used to hearing every day, error and risk, but in this particular arena. And then I will, since it's part of the report that I helped write and that I'm most passionate about are the communication of DNA results. And so just a few of those recommendations. And then I thought it'd be worthwhile to give you guys a little bit of information about what to look for in reporting and testimony. Okay, are we seeing the next slide? Please say yes.
Yeah. We're not seeing it, but I think if you go to slideshow and share the slideshow, you should be able to.
Yeah, I'm sharing the slideshow. I don't understand what's happening. Well, this is going to be real problematic.
Sort it out. We're all used to technical difficulties.
Right. I guess we should have tested the advancing the. So are you seeing the whole, what if I just stay, this would be terrible probably, but what if I stayed, can you see this if I advance from here?
Yes, we can. That's great.
Yes.
All right. Well, we will make this
right from there.
Even though it's a little ugly. Okay.
That's okay.
So let's define human factors really, really quickly, since that is why we're here, human factors and DNA interpretation. It's a scientific discipline that's really concerned with understanding how the human interacts with all of the different elements of the system. And you see this diagram here, and this mnemonic will pop up again here in a little bit, but you see where it intersects in this Venn diagram: people, environment, actions, and resources. So the system really is any set of these components that really work together to produce an outcome. And obviously we want trustworthy and reliable outcomes. So to err is human. I'm sure we've seen this, and this is just something to kind of crack a smile, I hope. When we're talking about human factors in this context, one of the goals was to reduce the likelihood and the consequences of errors. And these concepts really were kind of brought to the forefront in 2009 with the NAS report. And of course, ever since then, and some more in 2016 with the PCAST report. And I think sometimes DNA gets slapped with that label. I think we've probably all heard it, the gold standard, maybe a little bit more of the pattern disciplines that get picked on, but there are significant complexities in forensic DNA interpretation, especially when you're dealing with complex mixtures. And so I think that's where we're very similar to everyone else. We have some advantages in how we handle our data and interpret our data and the use of values. But the risk and error is everywhere anytime a human is involved. So understanding how we interact with our systems is really important. And risk can be perception here. You see this individual, sitting underneath, a propped up truck, maybe feels good about it, but then maybe there's like a power supply next to that. So sometimes we'll see that things end up happening as you progress in your career or you take shortcuts. And that is sort of one of those really typical human factors. So we know that we can't eliminate risk, but we want to figure out how to thrive in spite of that risk. So here's that mnemonic I was speaking about, and typically we have many more slides on this topic, but I try to condense it into one for you, that the people can be all different things relating to people, right? Their size, their gender, their perceptions, experience, knowledge, their health, their empathy, right? How they interact with other people. Your environment is important, and that's a chapter in this report that's very long. That work environment, lighting, temperature, workspace, noise levels, organizational culture, right? A lot of those things that we might take for granted, morale, how much that impacts people. Actions are what you need to, do that job, right? Or the actions are the things you do to perform your tasks, right? So those objectives, the sequence of your tasks, and what those tasks require. And then, of course, we always need resources to do the job. What sorts of things do we typically do? Our documentation, right? Because if you didn't write it down, it didn't happen. The time, the people, the training, and of course, money and things like that. So a little bit more about error. It's really, really difficult to define error. I think that even pinpointing a single definition can be difficult because it depends on the context. Obviously, it's something that's brought up in a lot of the admissibility standards for expert witness testimony. And so, it's really difficult to just talk about it without trying to focus in on what do we mean by error. So the definition could be tied to the reason for writing about error. Is it measurement error? Is it an instrument error? Is it a human error? Is it a communication error, which can be much more difficult to parse out the impact of those errors, right? Especially when you're looking at them holistically through the lens of a system. And so why do we fall back on human factors? And what lessons can we pull is really human factors is a science that leverages scientific knowledge, and that based from engineering and psychology. So there's been a lot of research, maybe not necessarily in the forensic domain, but if you look at some of the work that's been done in aviation and healthcare, nuclear power, like think about these industries that very high risk and, negative outcomes can be catastrophic. There are things we can do, and we can apply that to what we do every day and all of the forensic sciences. And of course, here we're talking about DNA interpretation. So we know this, people make mistakes, we're fallible. Even the best analysts or the best lawyers or the best people in any of their jobs are going to make mistakes. So I think thinking about these situations, that sometimes they're predictable or they're preventable. So that's really something that you try to look at when we are leveraging what we know about human factors from other disciplines and applying it to DNA. We know that a fear of punishment will prevent people from talking about errors. We want people to be open. That way we can work to find or correct issues in the system, right? Because people are just one part of that system. And really in particular here with these errors, we're not really talking about reckless behaviors. We've heard of a few instances even recently regarding DNA analysis, and that's reckless behavior that really warrants disciplinary action. But most errors do not really fall into that category. So this human factors report is part of a series. It's actually the third report in the series, and the purpose was to conduct a scientific assessment of the effects of human factors with the goal of, like I said earlier, recommending strategies and approaches to improve our practice and to reduce the likelihood and the consequences of errors. And so this scientific assessment is really an evaluation of the what we know from scientific or technical knowledge available to us right now. And we really tried to synthesize a lot of different types of knowledge and bridge any of those gaps if there were uncertainties, which there were quite a few, because there's not a lot of specific work on human factors as it pertains to DNA interpretation. So this is the other two reports. I have these links here for you, hopefully to have later. If you weren't aware, the first report in this series was the latent print report. And I believe that was in 2012. And then a couple years ago, this forensic handwriting examination human factors report came out. And then, of course, in May of 2024, we had this human factors report in relating to forensic DNA interpretation come out. And it's by the numbers, 400 pages, 12 chapters, 44 recommendations, 26 members. There was a lot going on in this. I wouldn't have expected anybody to have read the whole thing or retained the whole thing, but it is worth talking about a few things here today. So super quick, a few extra things about the human factors report. We wanted to examine these human factors as they relate to current policies, procedures, and practices within our field, and then develop some practices that are based on research to reduce errors. And then we want to publish those findings and recommendations. And we also wanted to include initiatives for future research. Our membership, as in the report, it lists who were the contributing members to this report. So I don't have that in here for you, but I think what's helpful to know is this report is a little bit, not a little bit, it's very different from maybe the NIST Foundation report that just came out at the end of 2024, in that we didn't send it out for a wide-ranging public comment. We did have external review. We went through several levels of internal review and comments, and then sent it out for external review. And what was important to us was to get input from the field, from people who had experience in these areas. So the membership, really the most important part about that was diversity, a range of perspectives. We had, human factors and cognitive scientists. We had obviously forensic DNA analysts, but also legal practitioners and legal scholars, as well as our steering committee. And it was really important for us to work together as a team. I want to drop this in here too, because it's got that QR code with this cute little dinosaur here. If you aren't familiar, this was a prerequisite for this human factors report, was to have a process map. This process map is extensive. It's over 40 pages long, I believe. But it is really a representation of the as-is state. And this is helpful to, pinpoint decision points and feedback loops, and really, how much variability is there in our field? And there's quite a bit. Lots of labs, depending on their size and their resources, do things quite differently. So I just wanted to put this in here for you to have this as a resource, and to let you know that it exists. Okay, I'll be using these terms today when we talk about, the actors that are involved in our recommendations. And this is really just for you to kind of have an understanding of why we're using these terms. Forensic Science Service Provider, I might even say FSSP, just to keep things short. Criminal Justice Partner is any entity. So that could be law enforcement, investigator, defense, prosecution, judge, or really anybody who supports the work completed by a forensic science service provider. Parent organization is typically the entity that is in charge of the crime laboratory. Most of us are in law enforcement, but there are some independent organizations. There are some prosecutors' offices that are in charge of crime laboratories. End user is anyone who would use a report. So that could be other DNA people, law enforcement, attorneys, defendants, complainants, fact finders. And then, of course, fact finder is how we define that as the person or the people who have been tasked with essentially making a decision in these cases. Okay, so for this, about 12 chapters in this human factors report, as I said, over 400 pages long, I'm going to be giving you snippets of these outlined chapters here. that mostly deal with a little bit with interpretation, but mostly the communication of DNA results, whether it's in a written form, which would hopefully be in a report, but maybe even some email communications, and then an oral form during so some sort of pretrial preparation or testimony. So this really is the bread and butter of communicating results, and it is a great summary of those, I think, 4 or 5 chapters for what we want you to take away in terms of communicating DNA results. First of all, I think everyone here understands probably how hard it is to even understand what we're talking about as DNA scientists sometimes when we communicate with you, because it can be really complex. And there's also some misconceptions about what DNA testing means in terms of, certainty. So those sorts of things are going to be, these concepts are really at the base of all of our recommendations. So one of them is we want DNA laboratories and DNA scientists to use likelihood ratios to evaluate their results. That really ties into balance, and that's assessing your DNA results and what they mean in light of 2 different points of view about what those DNA results mean. And we'll talk a little bit more about that later. So in that, for us saying we use a likelihood ratio, which is a numerical value, we really want people to think about minimizing the use of qualitative terms, which is just a fancy way to say words that can be misunderstood. Sometimes scientists use language that we think we know what it means. But we find when we have discussions and training and things like that, those terms can be really misunderstood. And a couple easy examples are words like match or consistent with. So we'll talk about that a little bit later. I would say the most important thing to take away from communicating results, whether it's through reports or testimony, is that DNA scientists include caveats and limitations in their reports and their testimony. And early and often, I think we have to really communicate what our results don't mean. DNA science is really trusted, rightfully so. I'm a practitioner. I believe in what I do, but I also think sometimes it can be overvalued. So we have to train our end users. We can give those caveats and limitations, but we have to train people also on what that means. And we want people to stay in their lane of expertise. And so we will talk a little bit about that more as we go. So I don't want to dig into this and spend a tremendous amount of time on this, but to not point this recommendation out there would have been a missing in the basis for the remaining recommendations that we're going to cover today. And so I mentioned before, promoting balance and transparency is really, really important. I think sometimes scientists tend to do, and I don't think it's on purpose. I think sometimes it's because we become so good at what we do that we just want you to trust us, right? Or based on my training and experience, that type of stuff. And I think what we really need to ensure that we're doing well through our interpretation and reporting and then communicating those results is making it clear to everyone why we're forming our opinion. So that's what we mean by transparency. So that could be better documentation, better note-taking, and the balance aspect really comes down to how we're interpreting our results. This table probably feels really busy to you, but it's important to me because I want to point out that as DNA scientists across not even just the United States, but across the world, the majority of us are only talking to you at that subsource level proposition, which is second from the bottom. This is just helping you understand if someone is a contributor of the DNA or not. But it's not helping you understand anything about if they're a contributor of a particular type of body fluid, like blood or semen. And it is certainly not helping you understand the activity that caused that DNA to be detected. There are a lot of additional pieces of information that have to be considered to help there. And that is a huge distinction that, again, this will be irritatingly repetitive today, probably how many times I go through that. But we have called this the hierarchy of propositions. Typically, we're never addressing that offense proposition, right? That tends to be the job of the court. But as scientists, what we want to do is assess our results in light of these different propositions. And right now, most of us are only doing that subsource level proposition, quote unquote, well. So we will move on from there. So circling back to likelihood ratios, again, balanced, transparent, two mutually exclusive, or another way to think about that is competing propositions. What that means is those two points of view cannot both be true at the same time. But also, what's very important to understand about that is that neither of those propositions has to be true. So what's really important in this context, and I think it is important to mention because it is a human factors report, and it's not something I'm talking about a lot today, but it's important to know that case information matters and it is necessary, because without that, we're kind of operating blind and we're not assigning or formulating those propositions based upon the case information that we have. Of course, there's case information that's irrelevant to us that we don't need, such as, the race of an individual, or if they have a lot of prior convictions or things like that. Numerous other examples. But without having some idea of what the question is, which is really what that previous slide is, or what are the issues in the case and what questions can we help answer, we're kind of operating blind. So that's why the likelihood ratio is really a flexible approach, can be applied to any different issues and honestly different evidence types as well. It's not just DNA evidence that's amenable to these sorts of evaluations. And then finally, with likelihood ratios, I think sometimes people get caught up in, yes, DNA scientists typically use numerical values to express what their evidence means, but it's not a measurement like it would be like when you see uncertainty of measurement with a certain amount of drugs or purported drugs. That's not what this value is. It's more complex. There's more decisions that go into it, and hopefully we're encompassing our uncertainty or what we don't know in the assignment of that LR. So precision, accuracy, not really applicable. The report talks about this a little bit. And so that's why also we make a few additional recommendations that we're not talking about today, but looking at that likelihood ratio as a way for that individual examiner or scientist to express the value of a DNA comparison. Now, if the science is good, we wouldn't expect a bunch of variability, right? But that talk is probably for another day. Okay, so we're moving on to that quantitative or qualitative way to express DNA results. And what that means is, should I use words or numbers? We are advocating for the use of numbers. Most DNA sciences already do this. But here's that recommendation in, I guess not black and white, but blue and white. We really want forensic science service providers to use likelihood ratios to evaluate DNA results. And we also want people to think about, instead of reporting such a precise number like 1,500,203, maybe we should just be using something a little bit easier to understand, like and rounding it down or truncating it to 1 million. These likelihood ratios are not that precise that they need to have 6 or 7 significant digits to it. And I think it's probably a little bit easier on the cognitive load aspect if people aren't thinking about all those different numbers. So I mentioned earlier, we're still in this chapter here, this mindset where words are numbers, which is better. Numbers are hard, but so are words. That was really the theme of our group as we were continuing to write these chapters, was communicating this stuff is really, really hard. We have a framework in place that uses numerical values. Sometimes what we have seen when laboratories transition to probabilistic genotyping, which came with it using a likelihood ratio method to give value, we were still relying on old terms like match or included or cannot be excluded to communicate our results. And I think a lot of that is what we just called a manual method hangover. We were when you're used to hearing that, you're used to saying it. Your customers are used to hearing it, right? Prosecutors, defense attorneys, everybody kind of may be on the same page. The jury never knows, right? Because this is probably the first time they've ever heard anything, but they do think that they know some things about DNA. And so I think that's something we really examined is, could we minimize some of that language? Because a lot of that language sometimes leads people to believe something really certain. Like if you say match and someone's like, oh, wow, that must be them, or that must be their DNA. But that is not what that word means. And so that word can be really misleading. There's lots of supporting literature on the potential misleading nature of that sort of words. And that's why we really want to rely on our numerical values. But then, of course, all DNA scientists know this, and I'm sure the audience does too, is a number is also not going to stand on its own. So we just want people to be thoughtful about what terms that you use to really explain the value of the DNA comparison. The use of verbal qualifiers can potentially be helpful to supplement a likelihood ratio, but there's going to be pros and cons to using those words as well, because again, words mean different things to different people. So no matter what, we're going to have to give some context. And then here's just a tidbit. This is maybe a little bit too in depth because I haven't been able to lay the foundation for this piece here, but typically the phrase exclusion, which again is qualitative language, it's also a decision by the scientist, really conveys a clear message about that person is not a contributor of DNA. But sometimes that might not always be the best way to communicate the value of the result. And there are ways to kind of go about that, which will also have some trade-offs. So we just wanted DNA scientists to really think about when it is appropriate to use exclusion, and then maybe sometime the limited circumstances that it could be really important to give a value of that DNA comparison, which would be a number typically much less than 1. Okay, so this is the recommendation. I've kind of already justified this. DNA analysts should state that the likelihood ratio value, instead of using a qualitative term that end users could really misunderstand. Those examples are match, included, consistent with, and cannot be excluded. And this is the part of that we threw in this excluded, because again, it's, it's a little bit of, not hypocritical, but we're saying use a number, and then we're like, but it's okay to say excluded. There's a little bit of a disconnect there, and it just really depends on the interpretation and how that's done, and making sure people understand the limitations of those opinions. So we're not going to get rid of words. We can't live in a world full of numbers, but we want to try to be as consistent as possible here. I wanted to give this example because this is from a real life case. And it's been anonymized, of course, but I think something that's, if the reader of a report, and again, every agency has their own reporting style, their own format. Some people use tables, some people use lists, some people have long paragraphs, right? All of those are going to have their potential issues. The issue with a table is that it could be misunderstood. Like someone could stop at this red box here and say, okay, John Smith cannot be excluded. Well, what does that typically mean? Typically, that means to people that John Smith is included. But really, if you read the likelihood ratio result to the right here, the results are of the order of 10,000 times more probable if 2 unknown people are the contributors than if this individual John Smith and 1 person are. And I think the issue there is that these results are providing 10,000 times more support for that alternative. So people are used to reading reports in a certain direction. They're used to saying, okay, if I have a large number, maybe that's beneficial for me in terms of a DNA comparison. But in here, this could be really misleading because the words cannot be excluded don't really align with what the likelihood ratio is stating. And there's lots of reasons that laboratories use this verbiage. And there are some decision points that are made about wider inconclusive, or some people say uninformative ranges. And so I think those are things, again, if they're saying that, you might want to ask your analysts some questions about what does this actually mean Does it mean that the results provide support for so-called inclusion, or that John Smith is a contributor, or is it the opposite? Because this could be confusing to anyone, including a DNA scientist that is used to doing this every day. Okay, so the thing that was easiest to settle on from a human factors perspective, and I mentioned this earlier, and we've got a resource in this report that I'm not showing you because it's really more for the scientists and what we're encouraging the scientists to do, but we have got to take a large role in communicating what the results don't mean, because people are coming in trusting DNA science, and they're probably thinking that if there is DNA there, that it is really probative or really valuable, or else someone wouldn't be going to court in the first place. And so something that's really, really important are these caveats and limitations that we are recommending people put these in the report. DNA testing is highly regarded, right? Basically just said that. We have to try our best to give these caveats. We cannot force people to read our reports, but please, please, please read the reports and read those, your methodology or an appendix to the report, and have conversations with your DNA scientist, because they might be using a word that they don't realize is misleading because they live in that world. Or you might be misunderstanding what some of these words or phrases mean in the report when that's not what they mean at all. And so a lot of those words, I said this earlier, but sometimes the DNA comparison results can be inferred to imply an action, how or when the DNA got there, or like a cell source, right? So words like major can be really misleading because it might lead someone to believe that just because they align with a major profile to a mixture means that they were the person that touched that item last or wore that t-shirt. And that is not true. And there's a lot of literature out there showing that. And plus, that is an entirely separate evaluation that would need to be done to even help answer that question. Sometimes we see things like item left behind by perpetrator, like in item descriptions that we would get in our lab, or swab of neck where suspect bit her, right? Like things like that can be really misleading because our DNA comparison is not answering that activity question. And then another one of the more common things that we'll see, and that we have some text about in the report, is the use of sperm fraction and automatically equating that to semen. That's really a method that we use in the laboratory, but oftentimes, depending on your laboratory's methods, they might not even be seeing sperm. And so it would really be an unjustified leap to assume that a profile is from sperm. So those are just things to keep in mind. So this first recommendation, this chapter 5.2, that's chapter 5. This is our reporting chapter. We want to reduce the potential for being misunderstood, right? And so again, this is kind of us getting back to words are hard. We want reports to have clear, concise, and unbiased or impartial language. So terms such as major contributor, you could throw minor contributor in there too, sperm fraction, these sorts of descriptors for us, we are not intending them to mean how the DNA was deposited or the nature of the biological material, but it certainly can read that way, right? So what we're saying is, hey, think about whether you need these terms in your report, first of all, and how, so we're gonna have to balance the value of giving those terms or using those terms with what our end users actually need. And then, hey, if there are terms you need to keep for whatever reason, those should really be defined in the report, and they should have those limitations attached to them. Next recommendation in here is one of my favorites. And this one is really talking again about these are the limitations that are really, really important for you guys to know. Really for everyone to know, the scientists as well, because sometimes I think we might also be confused. And this is for a report that is talking about essentially a DNA comparison. So these caveats and limitations should make clear that this first one is pretty standard. I think most laboratories that are using probabilistic genotyping are probably already have this caveat. But if any of the information changes, that really has the potential to impact the propositions or the scenarios or the points of view that we consider when we evaluate our DNA profiles. And some really easy things to think about are like if a potential alternative contributor is like a sibling or someone related, that changes the propositions. If there's an identical twin, that changes the propositions significantly, actually, and it actually dramatically changes the value of the DNA comparison. So those are things we need to know if those are questions, because if the information changes or the questions in the case change, then that means that the evaluation that we have already done probably isn't going to be appropriate now for the case. So that's what we mean by conditioning information, but it could really be anything. These next two are super important. Like, these are the takeaways from talking to you today, is that no matter how large a likelihood ratio value is, or if your RMP or CPI with your laboratory, how small those are, it doesn't matter how extreme those values are, that DNA comparison value by itself is not enough to conclude that someone is the source of the DNA. There has to be other case information involved, and that's not our decision. This is really who the source of the DNA decision is, that of the fact finder, because they do have all the information. We can certainly help with that, right? And that's why we're doing our DNA comparison, but that should not be the only information that is being used. And the next one is, think again about that hierarchy of propositions or those issues we're helping to address. We are only helping to address whose DNA may or may not be present. Those reports don't provide any information about how or when the DNA got there or why it's not there, right? We get lots of questions on both ends of that spectrum is to explain why there is an absence of DNA. So all of those things are really important when it comes to understanding the DNA comparison, or the DNA results are a completely separate evaluation, or more information will be needed to help address those higher level questions, which are typically what's going to come up in court, right? I wanted to just point this out to you in case you haven't heard about a couple examples here. And I also have this little screen grab I got from Peter Gill's Misleading DNA Evidence. But we have a few examples of these things in our human factors report. So I wanted to that's in chapter 5. It's a call out box. But this really reiterates what I've just said about DNA results, and that they are just one piece of the puzzle. I think you guys already understand and know this most of the time. But in my personal experience, when I've seen things go awry, or where the most pressure is put on DNA analysts, is when DNA is one of the very few, if maybe the only, quote unquote, piece of evidence. And that puts a lot of stress on the scientists. And I think that the scientists could not be expected to pull that case together just based upon the DNA comparison alone, right? You got to have other information. So there's been some interesting scenarios that have happened. This Adam Scott one both of these are actually, I think, in the early 2010s. But contamination happens. I think there's a thought that it's exceedingly rare. It probably is, but just imagine how much we don't actually know. That's why laboratories have, the standard operating procedures that they have is to try to minimize these things. But things do happen. And so that's why we are so reliant on our quality systems and our technical review. And this Lucas Anderson case is just a really great example of an incidental DNA transfer. This individual was not involved in the case. So I really encourage you to dig into this call-out box in the report, or look at click these links and kind of just dig into them to see that this is why it's dangerous when we put a lot of weight on only the DNA results, because stuff happens, weird stuff happens. Okay, so I want to give you a few key takeaways from DNA reports. Review the bench notes and the communications associated with the report. I think that's really, really, really important. I'm continually surprised that this doesn't happen all the time. Laboratories do not put everything in their reports. It's not to hide things, I think. But I do think sometimes there's not a thought about the system as a whole, and I think people might not realize that there is a whole bunch of other information that was used or relied upon to draw the conclusions in the report. The report is kind of, a summary. We want you to read it. We want you to understand it, but there's a lot more that went into that. So I cannot stress that enough. I think you really need to understand what your laboratory's language means and what it doesn't. And this is where I'm probably becoming irritatingly redundant, but there's no likelihood ratio value large enough to support a source attribution based on that DNA comparison by itself. And then again, the DNA reports you are seeing do not answer questions about how or when the DNA got there. And these other things are more technical things, things to look at when you are assessing DNA results. Is don't just rely like on a likelihood ratio value or a number and assume that it is quote unquote okay. The DNA results, sometimes we could be pushing the bounds. Are you dealing with ambiguity in this area? Is it low level or partial? This might be a signal that we need to review the internal validations or the SOPs of the lab to make sure that the conclusions they're drawing are actually supported by work they performed in their lab. Another gray area I see sometimes is that these suitability decisions, not every DNA profile is suitable for comparison. You have these issues in every forensic discipline, right? You have a poor latent print that doesn't mark well or only has a few areas to look at. Same with, a casing or something like that. It might not have a lot of markings, or a gun might be test fired in the lab and it doesn't mark consistently well. There are always going to be limitations to perform when you should perform an interpretation or not. And so that is something to look for. And I mentioned this earlier with providing, having a inconclusive or an uninformative range. I think we should always be looking at the value of those comparisons in the case record. And so if a laboratory isn't giving a value of that comparison, if they're relying on a word like inconclusive, I think that's something that might be useful to take a look at. Okay. So a few extra things from reports. This was in one of the recommendations earlier, but again, when we're pre-trialing and, maybe if we're getting this at the post-conviction phase, this is a little bit different, but, we want to make sure that evaluation is actually helping with the questions. And so if there are different potential contributors or comparisons that weren't performed, those things will impact the evaluation. And so we want to have enough good information, helpful, pertinent information that helps us formulate the propositions that reflect the points of view in the case. I talked about this earlier, just look at the reporting language that implies actions or self-source. Could that be potentially misleading? I think you're going to want to critique source attribution or identification statements. Were they justifiable? And then same with body fluid attribution statements, like it's a certain individual, the source of the blood. Okay, so now we're jumping right into our testimony chapter, which is chapter 6. And this is very similar to that caveats and reporting recommendation. And we felt it was so important that it really needed to be duplicated in the testimony chapter for the obvious reasons. This is when we're communicating to the fact finder. And so when we're doing our typical DNA reports, which again are DNA comparisons, right? We want people to understand that DNA results are only one part of the overall case, right? Don't over rely on the DNA results. I want people to know that DNA testing is no different than anything else that involves a human, and that errors can happen and that we are not infallible. The evaluation of that DNA comparison cannot identify an individual as a source of the DNA. This is like time number 5. I think I've said this today. And then similarly here, DNA analysts can't provide any information on how or when the DNA was deposited in a particular case based on a report only considering the source of the DNA. And this is a pretty hot topic right now. So this call out box, I'm not going to read through it. It has this green area circled or squared, I guess, because this isn't a perfect world that you might be able to get all of this out during testimony. It can be broken up with questions in between. But I think what's really important to tell the courtroom is, what this DNA comparison means and what it doesn't mean, and that we also communicate. Again, this is just an example, and this is really for our scientists, but to acknowledge that the DNA comparison doesn't help address how or when the DNA was deposited. Okay, I'm also not going to go through this. This is just to point out to you, there's a lot of talk about avoiding the transpose conditional, and here's what I will tell you. I think it's very important to say it right. I think that there can be a tendency to become the transpose and the conditional police, and I try to maintain a good balance between those. I think speaking correctly about your DNA results in light of the scenarios is important because it demonstrates that you have control over your discipline and that you understand the limitations of what you can and can't say. Not to say that we don't all slip up every once in a while, but this just is in that sort of likelihood ratio framework or Bayesian type of thinking. And that is that as a scientist, you talk about your results or the value of your results given the 2 scenarios, but you don't opine directly on so-and-so's the source of the DNA, or so-and-so had to have stabbed that person, or something like that. 6.3, mind you, again, I'm smashing in probably when we give these workshops, my chunk is usually about 4 hours-ish. So we're slamming in a lot of stuff in a short period of time here with really not a lot of buildup or leading you to the place that usually we lead people to. But we felt it was really important for this particular recommendation to talk about not performing new evaluations during testimony. This has a quality basis, right? Like we want to do things. I want someone always to review what I do. My goal is to not make mistakes, but I absolutely do. And so having a peer technically review my stuff is really important, and disclosing those reports and that information ahead of time so that it can be scrutinized is also really important for us continuing to do good science. So this is pretty obvious. I mean, speaking from my perspective as a DNA analyst that testifies, and I like to testify, that doesn't mean that it's not stressful. Quality is important. Like I said before, disclosure. And this is typically in our workshops, the point of time where people are like, I mean, yeah, of course I wouldn't do a new evaluation on the stand. That's crazy. I'm not going to do math. I'm not going to, write down formulas and do stuff like that. But there are some areas where we can quickly go astray. And I think that's when we start venturing into the, how did the DNA get there? When did it get there? Why did it get there? Is X, Y, or Z possible? Could the results be consistent with blah, blah, blah scenario? And that's where it gets really hard for us because we do have more expertise than the majority, hopefully all of the people in the courtroom. But how we go about giving those opinions, it needs to be done a little bit more scientifically. So this is our transition to this final chapter that I'm going to talk to you about today. It looks like I'm doing pretty good on time here, which is how or when the DNA got there. It is totally understandable that this is what the court typically cares about. DNA testing now is so sensitive that we can get profiles from a very, very, very small amounts of starting material. We weren't always that way, right? We used to need something tangible, like a large blood stain or if you've done cold cases, sexual assaults, there was almost always good profiles because there was seminal fluid deposited. And so I think we got, as an entire community, a little bit stuck there because those inferences that could be drawn there about the DNA results were much less risky than they are now when we're doing DNA testing, like on steering wheels or triggers of guns or spent shell casings at scenes. Such small amounts of starting material, we don't know what body fluid or cell type that it's in, or if it's in a body fluid at all, right? Or if it's even in a cell. So understanding DNA transfer and persistence and its application in these specific cases is complex. There's a lot of literature out there exploring these topics, hundreds and hundreds of articles. But what's very important to understand is those generalities, it can be really misleading to apply those to a specific case. And this is what we're saying here is this is a distinct evaluation. And this is a little bit where we're caught right now, is that we've kind of got a couple choices. And this is what we talked about in this chapter, which was this chapter 7 was ridiculously hard to get consensus on, and we didn't. So what we tried to do here was represent everyone's views about how we should go about doing this. Since these are oftentimes the questions we're getting asked during court testimony or pretrials, depositions, to ensure that the value of that DNA comparison is not carried up to an issue related to an activity. So just because you have a likelihood ratio of 1 billion, let's say, related to the individual on trial, does not mean that they had to have touched or handled that item for their DNA to get there. That they're just completely different. And the value of that evidence in light of those, what we call activity level propositions, is significantly lower. So that's why I have this yellow banner here, is that the value of the evidence changes depending on the question. Your subsource likelihood ratio values can be really, really high. That does not mean that they will be that high given the activities that are considered. So some labs are looking into doing this a formal evaluation that is done internationally in some places in Europe, like the Netherlands, Switzerland, Forensic Science South Australia has really great, smart people doing this work. But there are mixed views within the wider DNA community and everywhere, but here, of course, in the United States, and then as well as on the expert working group, because it is new. And it is not something that we are reporting. And so I think that's something to think about, is that, yes, DNA analysts know more, but do we know enough to be giving these sorts of opinions on the fly about what the DNA results mean? I have no doubt some people could probably do that well. I think for most of us, it would be really challenging. So this is the only recommendation I'm going to give to you today from this chapter 7. And it's a little nuanced and it's hard to go into, but I think I have boxed there occurred in a case because I feel like, this is my personal opinion, we leave room for this in the expert working group's report. Of course, we're going to have to educate the fact finder. They have to understand DNA transfer in the context of at least the type of samples probably being tested, right? Especially if they're trace amounts of DNA from items where we don't know a body fluid. But it gets tricky when you start applying what you think you know about the case, or what you think you know in general to the specifics of the case. I mean, one of those is that we don't know a lot of information we would need to do one of these evaluations formally. So I'm not going to dig into the communication problem so much here, but I do think conveying from a scientist, from an expert's mouth, that something is possible is really tricky. And I think it potentially can be really misleading, because what does that mean to the person hearing that? Does it mean likely? Does it mean expected? Or does it mean not very rare? Or does it matter our facial expression or our inflection? That's kind of scary for me. So I always look at this as, if it's something that a non-expert could say, which is it's possible, then maybe it's something that a scientist probably shouldn't be saying, especially in relation to a particular case scenario. And what I do want to reiterate here is I think we all, staying in our lane here is that's where that theme comes in, is talking about our results. So when you say scenario is possible, you're no longer talking about your results. You're kind of talking about what happened. So I think we need to try to maintain our impartiality and our humility as scientists and make sure that we are giving opinions that are based on things that are scientifically justifiable, not just our training and experience. Expertise in this area is challenging, and knowing a lot about a DNA comparison doesn't necessarily mean that you're going to know a lot or be able to talk about transfer persistence well in a case, or particularly in a case where you're testifying. So I'm going to leave you with a few slides about things to take away from testimony. A lot of similar things from reporting. I personally think it is important to provide limitations. Of course, we don't. I'm gonna quote my good friend, but I won't name drop her. Is we don't do the telling in court as a scientist, right? So hopefully, what we can do is collaborate with our criminal justice partners, people asking us the questions, to give us the ability to convey these limitations during our testimony. I think it's important for us to use clear language and define it if necessary, right? To understand, which almost everything we say is jargon, all of it. I struggle with this as well. I think it's really, really difficult. And we're dealing with attention span, right? We want to make sure that a statistical value is used to give value to the comparison. So thinking about those confusing words we heard earlier, cannot be excluded or inconclusive without an explanation, I think can be really confusing. Were the DNA comparison results overvalued, right? Was a logical fallacy used where, the DNA comparison was used to infer that the profile is unique, or compared to the world's population and things like that? I already said this first one, kind of talked a little bit about inconclusive, where what I've seen a lot is this is where sometimes we accidentally lack that balance or impartiality. But an inconclusive comparison is really an I don't know. So is the scientist making sure that they can't include or exclude, or that the results don't give support for whether they're a contributor or not? Because you can easily sway that depending on the question, and that's really difficult for scientists. And then I think it's important to pay attention to how the scientists and the legal parties discuss these activity questions, right? It's hard. They're really, really hard. It's hard to know also if it impacts the case, right? It's a holistic assessment of whether there's some sort of harm or error when communicating DNA science. Maybe you can mess it up a whole bunch and it won't matter, but I think there certainly are times that it could. And then lastly here, I think, again, going down the activity level type questions road is if scientists are engaging in that, and look, I'm not calling anyone out for this because I've been here. It's really difficult when you're asked these questions. You don't want to be a difficult witness, but you also want to stay in your lane for what you can say. And so if we are going down this possible lane, are we saying lots of things are possible? And really at this point, it kind of begs the question that we don't actually know, and maybe it's okay to not have an opinion. I think something that can be really troubling that, I'm seeing a little bit in the news right now is, statements about direct transfer being more likely than indirect. What does more likely mean? This is a comment directly on an activity. It's not talking about how likely or how probable the results are given to specific activity level propositions. And so I think, are people supporting their opinions here beyond that, based on my training experience, or are they claiming it's common sense, or that there's general trends in the literature? All of these can be potentially dangerous. So those are just things to look at from the scientific perspective. And that's all I got. I wanted to leave plenty of time, I hope, for questions.
Sarah, thank you so much for that presentation. And I think the way that we'll handle questions is folks can either raise their hands here in the room and I'll acknowledge you, or you can put your question in the chat and I will ask it to Jara for you. So we'll give folks a few moments to do that. So, Jared, the first question I have for you is, suppose that folks in this group, post-conviction attorneys, are reviewing cases and they come upon either qualitative language or an assessment of uninterpretable or other non-conclusions. What are the steps that you would recommend that attorneys take to understand more about those findings?
You have to have conversations with the scientists to understand what they're talking about. And hopefully if it's a testimony thing that's already happened, that it was clearly conveyed. But I think in a preparation or looking at a case to try it, I think everyone has to be on the same page for what those terms mean. And there are some times where, depending on, I skipped over a lot of stuff. This is a very likelihood ratio heavy presentation. So if you work with a lab or you're looking at information that is using that more of, binary approach or random match probability or CPIs, that's, I'm not going to say this stuff doesn't apply, because I think caveats and limitations still apply, but we had no choice in those days but to use qualitative language. So because all that statistic was talking about was essentially how rare or common that collection of information was, and that you had to communicate that the person of interest is included or aligns with part of that mixture. So, I'm not going to, especially from my perspective, I'm not going to say, never use those words. I just think what's really important is that conversations are had and that everyone understands what those words mean, and that when there is a value, that the value is clearly communicated.
Thank you for that. And folks, you'll notice that our post-meeting evaluation has just popped up on your screen. That's something we do as part of our cooperative agreement with BJA. If you go ahead and fill that out and just close it when you're through. And continue to drop your questions either in the chat or to raise your hand. Jara, another question for you. You mentioned how big this report is. This is a huge document. It has, I think you said, 26 authors. So if folks are time crunched, what are the most important things that you would recommend this group read in the report to further develop the ideas that you talked about today?
Yeah, I think where I would start is we have a summary of the recommendations and they're hyperlinked. So I think what you could do is go to that list, or if a particular chapter is about education and training, or we've got a chapter that's quality assurance and quality control. If that's something you're interested in reading about, go to that recommendation, and then you can hit that recommendation after you read it. If you're like, oh, I want to know more. It's really important to read the surrounding text. And so if you still don't understand, which you might not, because there's a lot going on in this report, or if you want to get more information about what led to the formulation of that recommendation, then I think you should reach out to the steering committee, which should be on that link I gave you. Has contact information for Melissa Taylor, who was the project lead for this, and works in the NIST Special Programs Office. But yeah, I really encourage you. I'm not going to lie, I'm the same as probably everyone. I think we all go to the conclusions parts of publications. We want to kind of get to the end quickly and see if it's even worth reading. And so I think the kind of how you might do that here is we have an executive summary, which is really short, but then finding the recommendations that resonate with you and then trying to read a little bit about them. And then if you need help, we all love to talk about it. So an hour is not enough.
That's great. I think that you just made yourself a resource to this community. We appreciate it. So we do have a question in the chat here that I'll read to you. Let's see. Give me just 1 second. So I will read the question verbatim here to make sure I get it right. So how are judges or juries that must make a final determination of how and when DNA was deposited on the evidence supposed to answer the questions if the scientist isn't recommended to communicate them? What are your recommendations there?
Yeah, it's a fabulous question. And this is what I'm spending my life working on. I think what's really hard right now is that if not us, who, right? And that's what that question is getting at. And I think, when we talk about this, we can always think about circumstances where it's dangerous or misleading to not say anything about, or to help the jury understand what the results mean in that context. But we have to balance that with how challenging is it to try to do that evaluation on the stand. So we have a bunch of steps we need to get to. First of all, it's what do we do now? How do we educate the jury? And this is kind of what we're trying to tackle now, at the beginning of our testimony, like maybe not necessarily case specific, but how can we make them understand what we want them to understand about DNA results and the actual interpretation we did? Give them a little bit of our knowledge so that hopefully they can walk into that deliberation room and make a good decision when they look at our results and then all the other information in the case. I think the other potential solution that we need to really, really look into in this country is if we can do these formal evaluations. There's a lot of complexities to that. I think the biggest one is getting a proposition that adequately reflects the defendant's point of view. And that's just where we're stuck right now. That some cases that might be really obvious and really easy. And I think there's some cases that don't need an evaluation given activity level propositions. There's enough other information in the case that the prosecutors might feel like this doesn't need to be presented. Everyone, based on the totality of this evidence, would get to the reasonable conclusion. So I think it's parsing out those situations where if we don't do an evaluation, given activity level propositions, then it's really misleading. And that can be really hard because it seems that we're looking back often, right? Of like, and that's kind of why I try to point, when DNA is your only item of evidence, we have to be careful, to reference the Amanda Knox case that gets referenced all the time. But there are the cases that I pointed out in there that if all you did was rely on a CODIS association to a person who was highly intoxicated and didn't have any memory and who might have thought that they actually did, murder someone, without that person being in jail, it's very likely they could have been convicted because of the strength of DNA testing. How would you get someone else's DNA under your fingernails if it wasn't related to the crime, right? So this was really hard, and I unfortunately don't have a solution. The expert working group certainly didn't. What we recommended was we need to get a group of people together to figure this out in the United States on if we can move forward with the sort of formal evaluation. But, look at how long it's taking probabilistic genotyping to make its way into all the labs. And not to say that's the be-all end-all solution. It has to be done well. It has to be done right. Validations, implementation, training, reporting, communication, all that stuff. We're probably a decade out at best, even if we started really working on doing this evaluation in our labs today. It is just as complex, if not more so, than if you're familiar with blood stain pattern analysis. And I think with a little bit more, I think of a solid methodology, a little bit more of a data-driven type methodology, because we are just based on how the evaluation is being done. So there are options out there internationally. There are people who are really trying to do this here in the United States. There's a lot of scrutiny. There's a lot of focus on that. And so I think getting this done responsibly is going to be really hard because it's going to depend on each case and what that case needs. So I agree. It's really hard. How's the jury supposed to know? There's no way they can know. And, it's also a good question that if we're not willing to say something, should they, right? Like we're putting a lot of burden on the fact finder there. And that's potentially scary to me as well. I think we're setting the stage for a pretty significant miscarriage of justice if it hasn't happened already. It's a little doomsday, but I worry about that a lot, that we're not doing a good enough job explaining what the DNA results mean. And by explaining, I don't mean just saying something's possible. I mean actually doing an evaluation, because a lot of times you do these evaluations and a likelihood ratio is going to be quite low, like 100, right? And we're spoiled scientists. the DNA scientists are. We're dealing with really large numbers a lot, right? Billions, trillions, numbers people have never heard before. And so I think that is the question is, saying nothing at all, I don't necessarily advocate for. We have those example responses in the report. I think it's just telling people really right now, it helps during the investigative phase, is that, look, I'm not going to be able to help. I am not going to be able to answer that question. So you're going to have to kind of fill in those gaps. And that seems not like a great solution either right now. But the trade-off can be, yeah, please go.
So I think to distill it down, it sounds like you're saying it's complicated and there's a lot more work to do. And I think like the end of any scientific report, what do we always see? The recommendations for future research. And I think that you've presented a lot of possibilities for what we'll see in the future. And of course, folks should read the report. It's linked in the chat, and these slides will be distributed. The recording will be available, as all recordings for these webinars are on the Quattrone Center website. Jara, we are so grateful for your time today. Really appreciate your expertise. Thank you to everyone who attended. We look forward to seeing you for the next edition, and have a wonderful day.
Thank you.